23 CR 8382, State of Texas versus David Bearfield. Could I have parties announced for the record for the state? Defense.
Stephen Harkowitz for Mr. Bearfield.
And are you Mr. Bearfield?
Yes, ma'am.
All right. I'm going to show you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places? Did you understand the state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram?
Yes,
That's a
ma'am.
state jail felony.
Notice how the judge spells out the exact sentencing range. For less than 1 gram of a controlled substance, even small amounts can carry heavy consequences up to 2 years in a state jail. This is a textbook example of how Texas treats drug possession very seriously.
Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to $10,000 fines?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
In my opinion, yes, Your Honor.
Mr. Bearfield, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, state is proceeding on the lesser included offense of possession of a controlled substance, penalty group 1, less than 1 gram. There's a $500 fine. State recommends deferred adjudication. There's to be restitution to SAPD for drug testing. They're taking in consideration County Court cause number 707516. Did you understand that to be the plea?
You said restitution. How much is it? It's like $60. Okay, yes, ma'am.
Did you understand that to be the plea?
Okay, ma'am.
The prosecutor isn't just asking for probation, they're layering in conditions like drug evaluations, community service, and restitution. This shows how the state builds a safety net of accountability, making it harder for defendants to slip through the cracks.
No.
Yes, ma'am.
All right. Defense?
Yes, Your Honor.
State?
It is, Your Honor.
Next, I'm showing you outside the agreement. The state is requesting that your deferred adjudication be for a term of 2 years. There'll be a TAP evaluation, 100 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Yes, Your Honor. State exhibit number 1 with all its attachments.
No objections, Your Honor.
Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor. We would waive the PSI.
Anything you wish to say on behalf of your client?
I would just ask the court to follow the agreement with this and grant Mr. Bearfield deferred adjudication.
All right. Are you employed?
Not at the moment now.
So how do you support yourself?
I haven't because I gotta have surgery on my back.
So how are you supporting yourself?
Well, I had some extra cash already. So that's how that worked. And then I have my Social Security.
What do you receive Social Security for?
That was for my surgery.
Who do you live with?
With my sister.
How many children are in that household?
Just one.
Age?
Doodlebug is he's 10.
Do you have any children?
Yes, ma'am.
How many?
Has a 4. And then one passed away.
I'm sorry to hear that. What are their ages?
14, 25, and the other one will be 6 years old. The one passed away. And then my other one is he's 30, and I have one 31.
Okay. All right. So if you're drug tested today, what are the results going to be?
It would be, should be clear.
Well, why do you say should be? What have you used in the past?
Not saying,
Well, when you were arrested, you had drugs on you. So what have you used in the past?
nothing. But
So you're
bank-
just walking around with cocaine?
No,
Well, according to the police report,
Here's a classic judge moment. She's cutting through the wordplay. When someone tries to downplay their drug use, judges will often press for honesty because it directly affects the type of probation or treatment ordered.
you were searched incident to arrest in a clear bag containing a white substance. The bag was found inside the small pocket watch above the right side jean pocket. And that's why we're here today.
yes, ma'am.
So what are you doing with cocaine if you don't use cocaine?
No, I was just at the club. So it's not a often use. It's just I was partying.
All right. So you've used cocaine in the past?
Yeah, in the past.
Okay. Why are we playing word salad?
No,
So I'm trying to
sorry.
figure out, no. I'm trying to figure out what conditions to give you, because you know what? I could send you out into the world with you saying, I don't have a drug problem. And then when you test positive, I will see on the docket sheet that you told me that you didn't have a drug problem.
Yes, ma'am.
So alcohol, cocaine, what else?
That's it.
So you never used marijuana?
No, not in a while.
All right. So that means, yes, you've used marijuana before.
Long time ago.
Okay. What are the drugs besides cocaine,
That's it.
marijuana, alcohol?
That's it.
All right. This is what I'm going to do. 3 years deferred adjudication, UA hotline, 90 sober meetings in 90 days, restitution to SAPD for drug testing.
Pay attention. Here the judge is tying reduced community service hours to completing parenting classes and vocational training. This is a smart use of probation to not just punish, but rehabilitate by setting life improving goals.
Proof of employment or SSI within 30 days. No employment as a home health care provider or with minors. No unsupervised contact with minors. Regular reporting by Zoom or in person. Field visits one time per month for 3 months. And then at probation's discretion, 200 hours of community service restitution. I'm going to require parenting classes. How far did you go in school?
I went to 11th grade. Then I went and got my GED.
All right. I'm going to want parenting classes. Once he completes parenting classes, 100 hours of community service will be waived. And you're either going to get a certificate from some type of trade school or either a degree. And once he obtains that, the remainder 100 community service hours will be waived.
This one.
And there's to be no contact with A's Up Sports Lounge located at 5520 West Military Drive. And that's 78242. Probation, is there anything else he needs?
That's A's, that's an apple.
Yes.
Nothing else.
Is there anything else you need from the court to be successful? All right, you're mumbling.
I said, no, ma'am.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes,
All right, good luck to you.
Take care.
You're welcome. Say, Mr. Backfield, are you all going to withdraw your motion or no?
Yes, sir.
All right, Mr. Backfield, you were placed on probation
Yes, ma'am.
and you haven't been doing well. Why not? Unfold your arms, please.
The information that wasn't correct.
All right, everyone, please whisper.
The information wasn't correct, so.
What information wasn't correct?
No, I guess when they couldn't get in touch with me,
All right, so your information was not correct?
I guess the number was wrong.
No, I mean, it's not its guess. Either the number was right or, all right. Didn't you hear what I just told him about honesty being the best policy here?
Yes, ma'am.
So where have you been staying?
At 6746.
I mean, who are you staying with?
Sister.
I'm sorry, who?
Sister.
Does she have any children in the house?
Yes.
What are their
Over here,
ages?
Can't remember his age.
Well, is he in school?
Yes.
Is he in elementary school, middle school? I'm sorry, what?
He's in junior.
I can't hear
He's
you.
in junior.
Junior high? Okay. So you drug tested today, what are the results going to be?
Should be clean.
All right, we're going to drug test you today. Is that you're still saying it's going to be clean?
Yes.
All right. Ms. Abrams, if we could have a drug test for Mr. Bearfield. All right, just have a seat.
This is where the truth cracks open. The drug test results don't match the defendant's story, and court dishonesty about substance use often backfires, especially when the evidence is as objective as a lab report.
Yes?
Judge, Mr. Fairfield's UA came back positive for cocaine.
Okay.
No other substances.
All right. Okay. All right, Mr. Bearfield. Come down. All right, how often are you using drugs?
It's been a while ago.
No, cocaine doesn't stay in your system for a month.
It's a bit of a while ago now.
I'm sorry, what?
A month ago.
Cocaine, what I'm telling you is cocaine doesn't stay in your system for a month. So your whole thing about I used a month ago, that's, according to the test, that's not true. So again, we're back to your level of honesty, and you need to be honest with the court. So how often are you using drugs and what are you using?
How often am I using them?
Mm-hmm. No, I'm not with you. So I don't know how often you're using. I don't even know what your idea of often is. So how many times are you using per week?
Once a week.
All right. So you're using once a week. Is this on the weekend or is this during the week?
And here's the turning point. Instead of revoking probation and sending him to jail for 2 years, the judge orders 2 weeks in custody for evaluation. This is a rare but powerful example of the court choosing treatment over punishment, hoping to break the cycle.
All right. And where are you using?
Huh?
Where are you using the location? Are you at your sister's house? Are you somewhere else? Where are you when you're using?
Like walking to the store or something. Not in the system.
So we have, yeah, this is where we are. All right, just have a seat in the box for a moment. All right, it's obvious to the court you have a drug problem. The state is trying to help you with that. I'm trying to help you with that. Based upon, everyone please whisper, based upon you not showing up even for orientation, they could file a motion to revoke, which they did.
Quiet down.
And then I would hear it. And then I could sentence you to the state jail facility up to 2 years. But probation wants to give you a chance. I want you to get healthy mentally and physically.
Yes, ma'am.
So this is what we're going to do. We're going to take you into custody. Oh, here's,
Sir, is there a reason why you can't be quiet?
Quiet down, please. I'm not gonna tell you again.
Okay, so here's the thing. Here's the thing. If you were revoked, you could be going to the state jail facility for 2 years. Everybody's trying to help you with your drug issue. So I know it may seem like a long time to you, but it's not 2 years. It's going to be 2 weeks. Probation is going to help felony drug court see if you are a good candidate for their program, and they're going to do a TAP evaluation. Then we can figure out what would be the best treatment plan for you. Do you understand? Yes or no?
Yes, ma'am.
All right. So the state is telling me they're going to withdraw the warrant. They're going to withdraw the motion. And what I'm going to do is alternate amend your conditions for a TAP evaluation and felony drug court in custody. You understand? All right. Good luck to you.